is the subject allotted to me to present in PCL platform. The High Court Act 1958, Act 5 of 1959. So all of our known about that our Constituent Assembly is adopted the Constitution 26th November 1979. After 7 years later, the state government of Kerala formed as per the States Recognition Act 1956. During that day itself, the High Court of Kerala established. That is also the same day on 1st November 1956. This particular act was enacted during 1958, but passed on 1959. It's Act 5 of 1959. The object of this act, that is already written in the preamble, to make provision for regulating the business and the exercise of the power of High Court of Kerala State. The objective is already written in preamble. So this is the provision regulating the business and the exercise of power of High Court of Kerala. We also see the relevant articles in this context. The article 214 to 221 of Chapter 5 of Part 6 deals with the high courts in the states. 24 articles 214 to 21 lay down the provisions relating to the establishment, power, and the jurisdiction of high courts. According to Article 214, there shall be a high court for each state. And this Article 215 provided that every high court shall have a court of record. I think yesterday's presentation, the presenter already told about the court of records. Court of records means the judgment or proceedings of the High Court or Supreme Court are kept as a records. This can be used as a evidence, or this can be this is no, whenever presented before the court, there's nobody questioned its validity, the evidence validity, and the power such court, including power to punish, contempt of the limitation of the contempt of court is 1 year, limited as per the Limitation Act. Next, considering to 216 provides every High Court hall consists of Chief Justice and such other judges. Then go to Article 226. Empowers to High Courts to issue certain rights. That means commands, orders, just like. Before that, we go to the Article 32. All of already known that. That is remedies for enforcement of right. Remedies for enforcement of right conferred under Part 3 of the Indian Constitution. This is the effective remedy of the violation of fundamental rights. What are the fundamental rights? That is right to equality, freedom, and education. Okay, and then freedom of religion, cultural and educational rights, and the right of constitutional remedies. This is itself is also a fundamental right. So, by the empowerment of 32, we can approach Supreme Court for any violation in the any violation in the fundamental rights deprived by the person. Okay. 32 is the most important for the citizen. So then come to the High Court. The Article 226 of the Constitution is empowers High Court to enforce the fundamental rights. The remedies provided, the effective remedy provided whenever the violation of fundamental right against the government by a person is in the form of in the form of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. In this, you can see for any other purpose, apart from the enforcement of right conferred to the by part 3, and for any other purpose. So this is a scope enlarging the High Court for admitting any case whenever any statutory or any legal rights were violated. So I think almost all are is known about it's concerned about the habeas corpus mandamus, but habeas corpus is remedy against the illegal detention. So this is sometimes exception is given for the single judge power of the High Court. A mandamus means a command writ issued against the government, and quo warranto is the issued against the person who holds the public office having no authority to hold the office. Certiorari and the prohibition, both these rights are judicial writs. The writs are issued against a quasi-judicial authority and a subordinate judicial authority. So then we go to Article 226, 227. This is the power of High Court to superintendents all over the courts and tribunals throughout the territories of its jurisdiction. So Kerala having a jurisdiction of Lakshadweep and entire Kerala. So all the courts or tribunals all in these areas so be superintended by the High Court of Kerala. This Article 230 extension of jurisdiction to High Courts to Union territories, and Article 231 provides the establishment of common High Court for 2 or more states. Punjab and Haryana having one High Court. This is the example. So all are known about that. Then whenever go to an for particular this act, so any act having a preamble. So the objective of the act is mentioned in preamble. So objectives of the act is I already told. Then there is a short title and commencement is also there. Every act having a short title. So this particular act having title of Kerala High Court Act 1958, and commencement is date of this notification itself. So any act we are in writing a when writing an examination, so the definition is always in section 2, most probably. So definition means the whatever may be the literal meaning, the term is specified in the act having the particular meaning is as specified in the particular meaning in specified in the act. That's it. So other contents are powers of single judge and powers of bench of 2 judges, appeal from judgment or order of single judge, cases to be heard by full bench under the direction of Chief Justice, and procedure on reference to full bench, and powers of the vacation judge. Then we go to the powers of the single judge. So while enacting this law, so at that time the prevailing CRPC is 1908. Now it's 1973. So he can forward to admission of appeal from pauper. That means pauper party. So that means without paying any court fees, he is empowered to admit the appeal. Then exercise of original jurisdiction under the law or the time being in force. Then powers under section 115 of the CRPC, that means the revisional jurisdiction can be handled. Under section 22 of the Small Cause Court Act 1957, revision decree or orders of court of small cases. Then any matter of interlocutory character in appeals and other proceedings. An admission of appeal presented after expiry of period allowed by the law of limitation. Admission of an appeal from the judgment order any criminal court. Admission of an appeal from a judgment or order of any criminal court. While admission, exercise the power while admission. Okay. Then exercise the power of revision, revise the proceedings of any criminal court. There is a proviso is there, provided the single judge shall not impose a sentence of death or imprisonment of life. The single judge also exercise the power conferred by the section 42, 426 and 498 of CRPC 1898. In this section, the suspension of sentence during the whenever the appeal is pending, so he is power to suspend the sentence at that time, that appeal period. So then power to direct admission to bail or reduction of bail. Or he also exercised the power under section 24 of Code of Civil Procedure Code 1908, transfer and withdrawal of civil suits. Also, also exercise the power for issue of writs except habeas corpus writ. Article 227, to superintendents of courts and the transfer of certain high courts to subordinate courts. This power also exercised by the single judge. Then Civil Court Act, the adjournment of civil court is also, he can exercise the power for adjournment of civil court. Then regarding the appeal from the judgment or order of criminal court, appeal can be heard, except the appellant or a person tried with him the sentence to death or imprisonment. Or even he is sentenced to death or imprisonment, he is not empowered to hear an appeal by a single judge, provided in exercise of such power, the single judge shall not impose a sentence of death or imprisonment for life. There's from the original decree or order. This is 10,000. At that time, this is 10,000. Nowadays, I don't know exactly the limit, the amount of the value. Value. Then original decree which is appeal relates to cost. Any cost is from the any order made under rules which are appeal expressly allowed by the rule, that can be heard by the single judge. Then appellate from any appellate degree or order under Section 73 of Insolvency Act 1955, appeal to High Court. That is appeal to High Court. But now all these acts are superseded by the Insolvency and Bankruptcy Act 2016 come into force. So I think this is not relevant, not having the power to head a single judge. This is a separate tribunal is there. Under Section 76B of Code of Criminal Procedure 1898. This is I go through the particular section, but then powers of bench of two judges. That is main power is any matter in respect of which power I court exercised by a single judge. Whatever the matter can be heard by a single judge can also be heard by the bench of two judges. Regarding in case of appeal from the decree or civil court, except those coming under the Section 3. The coming actions, the 3 is provided with the power of single judge. So, except those coming from appeal. So, he is the bench of two judges. From the judgment of criminal court, which is a sentence of death or imprisonment or life, he can pass it to appellant or the person tried with him. Even though the sentence, the appellant is sentenced, even though the person is sentenced for the death penalty or imprisonment or life, the appeal can be heard by the bench of two judges. in the reference jurisdiction, so reference to the High Court by district judge or judge of small court, like all references are admitted by the bench of 2 judges. Under CRPC 1898, under section 307, the procedures of session disagrees with the verdict, and sentence of death was submitted by the court of session. That also they power to head the reference. And that application under Rule 2 of 45 of First Schedule of CPC 1908, and the application in exercise of power conferred by 498. In Section 498 provides that power to issue directional nature of habeas corpus. So the bench of 2 judges can the power to head the petitions of habeas corpus and issue the order accordingly. They are having the power. So the other power relates to habeas corpus, writ of nature of habeas corpus, and appeal from a single judge, any appeal from single judge order or judgment. And regarding the full bench, this is a full bench is heard the cases by the direction of the Chief Justice. So the Chief Justice may direct that any matter be heard by the full bench. So under the direction only, the full bench hear the cases. Procedure is to reference to full bench. Whenever question of law is referred to a full bench, may finally decide the case or retain, which an expression of opinion, the question is referred to final adjudication by the bench, which is referred in the question. In the absence of either or both referring the judges. That means any question of law can be heard by the full bench. The powers of the vacation judge. So the vacation judge is nominated by the Chief Justice during the adjournment of the High Court. Such a judge having all the powers of the High Court, that is limited to the powers of the single judge, one judge. And so the Chief Justice having the competent to constitute a bench of 2 or full bench for hearing any case during the adjournment of the High Court on the vacation. And now present strength of the judges in the High Court is 35% permanent judges, and including Chief Justice, and 12 additional judges. So the appointment of acting Chief Justice, Article 223 provides the appointment of acting Chief Justice. Whenever office of the Chief Justice of Kerala High Court vacant or absent or unable to perform duties, can appoint an acting Chief Justice. Then Article 224 also provides appointment of additional and acting chief judges, but no, there the period is not exceeding 2 years and the age limit is 65, because all the judges are retired on superannuation by 64 years. So this is what I want to say, sir.